clarifying misrepresentations about law enforcement interrogation techniques. Social psychologists, academicians, and defense attorneys oftentimes misrepresent law enforcement interrogation techniques. In our discussion about the kinds of things that they say in this presentation, we will refer to that group as the critics. We have prepared and posted on our website a 36-page document identifying what these misrepresentations are and providing you with accurate information in response to their criticisms. In this particular video presentation, we're going to highlight a few of them just to give you some idea of the kinds of issues that we address. Critics claim that the purpose of an interrogation is to secure a confession, and some of them say at any cost. Well, that's obviously not the case. The purpose of an interrogation is to learn the truth. Now, in most instances, the truth is the guilty person acknowledges that they did commit the crime and gives us corroborating details for what and how they did it. And the reason that most of these interrogations result in confessions is because we teach to reserve interrogation for those instances where the investigative information clearly indicates the subject's probable involvement. So we're interrogating people who we think, based on the evidence, are the ones who committed the crime. We're not just arbitrarily picking people off the street and interrogating them. Now, there are several other successful interrogation outcomes, however. For example, you may have an individual who did not commit the crime, but it does acknowledge to you in the interrogation process that, look, I do know who did it. I didn't tell you guys because he's a friend of mine, but then they go on to articulate what and how the person did it and how they know that. Oftentimes in an interview, the subject gives an alibi. We go out and check out the alibi, and if we find out the alibi is false, is not accurate, that they made it up, it's going to heighten our concern about their possible involvement, which will lead to a follow-up interview, possibly even an interrogation. And sometimes the subject will tell us during that interrogation, look, I didn't commit the crime, but I was somewhere that I wasn't supposed to be. I was with someone I wasn't supposed to be. It was embarrassing for me. I didn't want to tell you guys. So, I was hiding that during the interview, but, I had nothing to do with this. And then subsequent investigation will help resolve that issue. And there are those instances where the investigator goes out and says, look, I don't think this is the guy. I don't think this is the guy. I think we better look somewhere else. Critics oftentimes describe the interrogation process by using such descriptions as structured to promote a sense of isolation, designed to increase the anxiety and despair associated with denial, manipulate and deceive the suspect into believing that their situation is hopeless. Well, let's address those. Obviously, we do recommend that interviews and interrogations take place in a private setting, but we never teach investigators to detain non-custodial suspects or to isolate them so that they cannot reach out and contact others. We never teach to do that. And if a person's in custody and they're advised of the Miranda rights, and if they invoke those rights, it's over. We're not going to interrogate somebody who's invoked their rights if they don't want to speak to us or they want a lawyer, etc. So, we're making no attempt to isolate them and keep them from others. We never teach or recommend that the investigator should try to increase the suspect's feeling of despair or hopelessness. In fact, we teach that is an improper tactic to use. We have many cases on our website that point out the fact that threatening somebody with possible inevitable consequences if they don't confess is a very high risk factor in causing false confession. So we teach not to do this. You don't want to create an environment where they feel desperate or hopeless. You want them to feel that by telling the truth, they'll be able to explain exactly what and how and why they did what they did. It is interesting to note that the Supreme Court recognizes the need for interrogations to take place in a private setting. Over 6 decades ago, they said, quote, often the place of questioning will have to be a police interrogation room because it is important to assure the proper atmosphere of privacy and non-distraction if questioning is to be made productive. Critics describe the interrogation process as one in which the investigator engages in minimization techniques. And what they mean by that is that the interrogator tries to minimize or downplay the consequences of the alleged act. They suggest that minimization communicates implicitly a suggestion or promise of either leniency or reduced punishment in exchange for cooperation. They also describe that the investigator offers the subject an inducement. The investigator expressively promises or implies leniency in exchange for confession, or, on the other hand, threatens the subject or implies the subject will face a more severe consequence or treatment if they don't confess. The only problem with this description that these critics used and applied to interrogation is that they're describing behaviors that we teach investigators should never do. In fact, if you look at one of our other presentations on this YouTube channel called The Core Principles of the Reid Technique, among other principles, you will see two of them that are very prominent, which are: do not make any promises of leniency, and do not threaten the subject with any kind of physical harm or inevitable consequences. Not only do we know that that might create or enhance the possibility of a false confession, but the courts have long suggested that those are inappropriate behaviors. Critics correctly point out that many false confessions come from juveniles or individuals with mental or psychological impairment. And we agree, they are correct. And so some of the precautions that we teach to exercise when questioning these individuals include: do not lie about the case evidence. Do not tell a subject you have a witness when you do not. Do not tell that juvenile you've got his fingerprints when you do not. We teach to exercise caution when evaluating a youthful subject's behavioral responses. Due to their immaturity and their corresponding lack of values or sense of responsibilities, the behavior symptoms they display may not be reliable. When a juvenile is younger than 15 years old, who has not had any prior experience with the police, when they are advised of their Miranda rights, the investigator should carefully discuss and talk about those rights with the subject, not just recite them, because we want to make sure that they understand them. These are just some of the issues that we address in our paper, Clarifying Misrepresentations About Law Enforcement Interrogation Techniques. You'll find this document on Reid.com. And in it, we talk about many other issues and appropriate responses when presented with those issues. Thank you very much for taking a few minutes to listen to this presentation.